This conference will now be recorded.
Good morning, everyone, and welcome to the exclusive right of sale listing agreement transaction brokerage version of workshop training. This is part 4 of our Engage series for Right Choice Realty. Today, we're going to be talking about the exclusive right of sale listing agreement, how you fill the paperwork out, as well as some background information on how you fill the document out, where you gather your information, as well as a seller's net sheet. As I said in the preamble, if you will, that there are open mics available on our training today. So I'd like to ask some questions, and if anyone would like to respond, you are more than welcome to. What is the reason that we use the exclusive right of sale listing agreement? Does anyone know? Why do we even do this agreement, and who is it between? Anybody?
So this is Chris. I would say, well, it's between the seller and Right Choice Realty, acting as the broker, and the exclusive right gives us the exclusive right for listing the home and no one else during that time frame.
That is absolutely correct. The exclusive right of sale means no matter where a buyer comes from, Right Choice Realty and you as the listing agent will receive a listing commission. So as we say in the mentoring program, he who lists gets paid. So if you have this exclusive right of listing agreement, it doesn't matter where the buyer comes from, whether you procure it yourself or another realtor brings you the buyer or even the seller brings you a buyer. So this is a blanket listing agreement that protects you and the brokerage as far as your commission is concerned, as far as listing transactions go. Okay, so we're going to just briefly go through the lines of the form and make sure everybody has an understanding. On your screen, I believe you can see an example form. Can everybody see that? It's kind of filled in generically with some verbiage there, and this form and this training file is available for everyone. You can actually see it, make changes to it if you want to, play with it, practice at your own.
Could you make it larger, Dawn, please?
I'm not sure if I should make it larger or not. Let's give it a shot.
That looks good.
Can you see that?
Yes, thank you.
Okay.
That's better,
Right.
Thank you.
No problem. Okay, so we're going to start with line 1. It states clearly this is the exclusive right of sale listing agreement, and it is between all sellers named and Right Choice Realty. You may add after this line, if you'd like to put your own name in there, you are more than welcome to. Let's go back to line 2 for a second and talk about our seller. If I get a phone call this afternoon that says, hey, I'd like for you to come out and give me some information on listing my property, great, perfect. Let's set up an appointment time. I have some homework to do. What do I do to get myself prepared to know who my seller really is? Where do I find that information? Anybody? Where can I find out? LIPA, okay, but where at specifically? LIPA is the property appraiser's website, but what exactly am I looking for? Because if you open the property appraiser's website right now and you look at a specific property, right underneath the legal description and underneath the seller's information, it's going to say in bold red letters, do not use this for legal purposes. So where do I need to look to find out who my seller really is? We're going to pull the last recorded deed that was executed to find out who the legal owners of this property are. And that's who we're going to put on line 2. Now, what if it says 2 or 3 people are my sellers and I've only talked to one of them? Can I list the property with only one person's signature?
Nope.
No, I can't. If there are 3 people listed as sellers, how many signatures do I need?
3.
3. I have to have everyone that's listed as a seller sign the document to agree that we're listing the property for the specified terms that we're about to go over. What if it's in the name of an LLC? What do I have to have?
Managing member.
Managing member, correct. Where do I find that information?
Sunbiz.
In Florida, you can look on sunbiz.org and you can look up the name of the LLC and find out who has the legal authority to sign the listing agreement for you. What if it's in the name of a trust? What do I have to have?
The trust stating who the trustee is.
That is absolutely correct. You would need to have the actual recorded trust so that we can find out who the trustee is that has the legal right to sign these documents. That is absolutely correct. Okay, we're going to just skim through this top section. It's pretty self-explanatory. I will tell you that line 6 is incredibly important. Right Choice Realty prefers that realtors take listings for no less than 6 months. Why do you think that's important? Why is 6 months a good time period to have a listing for? How about for your benefit as the listing agent for marketing purposes? How about having time on the market, depending especially on what type of property it is, to give it adequate exposure and to be able to do a good job, to have enough time to service this listing? Because realtors very often put money out of their pocket to promote a listing, right? We market our properties, we put them in the appropriate lead streams so that buyers can find our property. And if we don't have it for at least 6 months, that's a disservice to you as the realtor. You're going to spend money that you may not have time to recoup. Okay, next section at line 8 talks about the fact that we cannot, or line 9, I'm sorry, we cannot discriminate on who our buyer is. It doesn't matter if the seller agrees or not with that person's religion or that person's, preference in any personal item. We cannot discriminate. If a buyer comes to us and they match the terms of this contract or acceptable terms of this contract, the seller cannot discriminate based on any of these protected classes. Does everybody understand that? It used to be the seller could, reject an offer for any reason they wanted to. But if a buyer could prove that the seller said, no, they don't like me because of my religious orientation or my sexual orientation or because I have children or anything else, then that's discrimination and they can actually sue you. And they can sue us as the realtors and the brokers as well. So that's why this statement has been added to our contract. Okay. At line 12, we're talking about the physical description of the property. Line 13 is the actual street address or mailing address that's on the mailbox. This is how we find it. And at line 15, we're talking about the legal description. You're going to see a little note written in there. This is not going to actually be on your real document. You're going to put in the legal description that is provided on the last recorded deed also, not what is listed on the property appraiser's website or any other site that you find. We only want to use the property information located on the last recorded deed that matches the seller's description. There is a little blurb there at the end that I would add it for safety if you will, that says legal description provided to be verified by a licensed title agent or real estate attorney. This is just one more layer of protection to make sure that the seller is really who the seller says they are. Boy, I can't speak today. And also that we have the right property when we convey it. This also protects us from the buyer not being fully informed about what they're purchasing. Any questions about that?
Dawn, this is Chris. I'm wondering, given this is like a sample document, which I'd like to download afterwards, is it possible to add just a little phrase to that saying legal provided from property appraiser's site on deed? So I don't forget.
Absolutely. You may absolutely do that. You certainly can. And if you can also add it on page 4 of the contract that we're going to get to here shortly, in the additional comments, you could make a note there as well. You certainly can. I don't think there's ever too much disclosure. I think whatever you can disclose is better. Okay, at line 17, we're talking about personal property, which includes appliances. What is personal property that might be included in a sale? Think carefully about this one, and then we're going to discuss it. What might be personal property that we want to add on this line? Anybody have any ideas? How about
maybe a jacuzzi or something?
Yes.
A jacuzzi,
Yeah, jacuzzi, shed fence, good, Donna. How about light fixtures, ceiling fans, appliances such as washer and dryer, garage door openers, anything and everything that stays in the house when it sells needs to be listed. And you can add the attachment you can see on line 18. If you don't have enough room, add a blank piece of paper and make it part of the listing agreement. You want to list it all, okay? At line 19, this is regarding occupancy, and there's only two choices. It either is or is not currently occupied by a tenant, and if so, when does the lease term expire? Why is this important to know? We talked about this.
The buyer would have to honor the lease, I believe.
Correct. If there's a fully executed lease, a written lease in place, the new buyer is going to have to honor that lease term until it expires. Why would this make a difference for a buyer purchasing the property? Why would they care? Correct, Aaron. If you sell before the lease is up, the buyer has to honor the lease. Why would that potentially impact a buyer? What is a buyer?
They can't move in.
Right, correct. They can't move in. So if they wanted to live there, that's going to be a problem. What if they are buying it for an investment property and you have a lease in place and the current lease value in that neighborhood is $1,500, but you have a lease for $900 for another year, and the buyer has to honor that? Do you think that that's going to be a positive cash flow for them? Do you think that that might impact their purchase price, or do you think it might impact their plans? Yeah, no, I agree. That's probably going to be a big one. So that's why we have to give the information when we are listing. We have to find out what the terms of those leases are. In our session last week, we discussed the as-is contract versus the standard contract, and we talked about the fact that we have to have the lease copy and the accounting of all of the deposits made to a seller. So that's something that you're going to want to gather while you're doing your listing appointment. If there is a current lease, we need a copy of it. We also need an accounting of when deposits were made, how much the deposits are, is there anything that's going to be returned to the buyer, I'm sorry, not buyer, returned to the tenant when the lease expires or when it is canceled. You know, what exactly is the entire financial picture for that lease as it affects this property? When you get it under contract, you actually take that information provided by the seller, and the tenant has to provide an estoppel letter that says, yes, this information is correct. I paid X a month. I've made this kind of a deposit. I have a deposit of X. My last month lease was paid. And you have to compare them and provide all of that to the buyer. So you want to know the day of your listing appointment whether or not there is something that you need to gather more information for. Does that make sense? Okay. Okay, at line 21, we're going to talk about prices and terms. This is the price that you're going to put on the MLS to begin with. It is incredibly, incredibly, incredibly important that you make this price at line 22 a realistic listing price, something that you could actually get an offer on in a short period of time. Doesn't mean make it a throwaway price. It doesn't mean make it, you know, a below market price. This is a reasonable, verifiable market value, because this contract is legally enforceable. If you provide these terms to a seller, the purchase price, the finance terms in the time frame that they ask for, if they deny to take an offer that meets those terms, you are still owed your full commission for whatever you've listed it for. So we don't want to take overpriced listings. We don't want to take a short time period listing. We want something that we can actually work with, because we don't want to work for free. We want to actually have an enforceable contract. Okay, so make sure you've done your homework. You've done your CMA, you've done days on market, you know what the community is about, if it's in an HOA or a condo association, that you know everything that there is to know about this property from top to bottom. And you've had an honest conversation with your seller that your offered price is a realistic price. Okay, at line 23, we're talking about what kind of financing terms will the seller accept. Different types of property are going to dictate, without the seller having anything to do with it, what kind of financing we can take. Certain condo associations will not be able to be mortgaged with an FHA or VA product, and that's going to be up to the lender to tell you whether or not a particular development is going to qualify for those for those types of financing. So maybe I can only take conventional or cash. Maybe the seller will hold paper. Maybe they'll do seller financing at line 24. If so, what are those terms? And never be afraid of seller financing. If you get something that is a unique situation and the seller is willing to do financing, don't be afraid. Just ask for help. We'll be happy to help you work through financing terms with seller financing. So you need to be very clear with the seller. Are they willing to meet FHA and VA guidelines? If you don't know what those guidelines are, go back into app files, pull your FHA VA rider, and read through what those guidelines are going to be obligated for the seller to meet before you check these boxes. It's very important that you understand that for VA and FHA, the seller has a little more work to do and has a little bit more qualifying to do for a mortgage to be funding. Okay, so we want to make sure that we are fully aware of what those requirements are going to be, as well as inform our seller. Any questions about financing? Okay, at line 37, we're talking about seller expenses. This is discount points or offered closing costs. This is going to be that seller concession that we often ask for, or a buyer asks for in a end user product. Very typically with FHA, VA financing, you're going to have seller concession. If you know that that's the type of property that you're selling, you can right here address it with your seller. We're going to do it on the net sheet in a little while. You can talk to your seller right now and prepare them that a buyer's probably going to ask you for a certain percentage of the purchase price back to cover their expenses. If you are a very proficient listing agent, you're going to go over this and prepare them for a certain percentage right now. Usually it's no more than 6%. It's probably closer to 4.5% or 5% is all the buyer's going to need. Sometimes they'll need less depending on their personal situation. But if you really want to prepare your seller and be in a good position when an offer comes over, you do want to address this line 37 at listing. Okay. All right. At line 39, we're talking about what the broker's obligations are to the seller. We're not just going to list it and forget it. We're going to make a diligent and continued effort to sell the property until a contract is pending. Okay, that means, yes, put it in MLS. Yes, we're going to market appropriately. Maybe that's an open house. Maybe that's flyers. Maybe that is drone photography. I don't know. It depends on what your particular property is that you list, and every single property will be different. Okay, but a diligent and continued effort to sell the property. We're going to put it in the MLS system and multiple listing here at line 41. We're going to make sure that it is appropriately and properly marketed. Whatever this listing contract says is what has to be conveyed on the MLS. So if you tell the seller down here in a little bit that you're going to split a commission, a compensation for 3% of a purchase price, you have to split it 3%. You can't change it unless you tell the seller and you have it documented. If I have it listed for 160,000, I have to have it in the MLS for 160,000. Okay, you can't make it up as you go along. You have to follow your own contract and follow the rules. All right, unless the seller directs the broker otherwise in writing. You have to do everything in writing, every change that you make. Okay, I know I beat you up with the writing stuff, but it's required. It's very important that you get it in writing. On the second page at line 47, the broker authorizes the seller, or the seller authorizes the broker, I'm sorry, to advertise the let's try that again. Advertise the property as the broker deems advisable. This is you as the professional deciding how should this property be marketed. If it's a first-time home buyer's property, you know that that's what it's going to be. The price point is below the average median sale price for the county. You know you're going to get multiple offers and it's going to go really, really fast. You probably don't need to do much more than put a sign in the yard and put it on MLS. But if it's a unique property, maybe it's acreage, or maybe it's an entire condo complex building. Maybe it is, I don't even know. Maybe it's something off the wall that is not in the normal flow of listings, not what people expect. You need to decide as a listing agent, what is the best way to sell this property, and have a plan before you take the listing. You need to know all about your property and have a plan to tell that seller what I'm going to do to get this sold for you. And then you need to do that. And you need to, this is a promise that you're actually going to do that. And not only that, you're obligating the broker to that promise as well. Okay. At line 51 and 52, you do not want to check these boxes. If you do, it can't go in the MLS. It can't go on third-party sites like Zillow or Realtor.com. It can't be advertised if it doesn't have a property address, or it can't be displayed on the internet. So if they absolutely are adamant that I don't want my address on here, then they have to initial at line 55 to understand that they will not have MLS access. Does that make sense to everybody?
I'm sorry, it does not to me. Just one more time. If they elect not to put their street address, are you saying that it would not be listed on Zillow and the like?
It may not be listed anywhere on the internet if they opt out to not have their street address, because how is it going to be listed? How could they possibly find it? Everything is by street address. So, and it only pulls to Zillow unless you manually add it. It pulls from the MLS. If you can't have the MLS, or I'm sorry, if you can't have the address on the internet, you cannot put it on the MLS.
Okay.
Okay? So that would mean just a street sign and any direct marketing that you could do for them, which is fine. You can do that, but their time on the market is probably going to be greatly increased if you do that. Okay? At line 56, we are going to place appropriate transaction signs on the property. Appropriate signage meaning if it's in a community and they have a rule that says you have to have a special sign, you're going to buy that. If it's on, you know, I-75 and it has great road frontage, you're going to put a big one on there. Okay? What instance would someone decide not to put their address on the MLS? That's a good question. Let's back up one step. Sellers sometimes get very nervous that people will find out that their home is for sale. Maybe they are in a community that they have a lot of close personal friends and they're having a personal situation such as a divorce or a death in the family, and they don't want their neighbors in their personal business. Maybe they're a first responder and they don't want their property advertised. Maybe it's a, this is going to sound cheesy, but it could be, you know, someone that's in witness protection or someone that they don't want their property information advertised so that they could be found to be moving. So there are a lot of situations that could occur. Sometimes you just get a finicky seller who thinks that if their property address is on the MLS that someone can gain access to their home. You know, they don't quite understand how it works. That does not give other realtors a free pass to their property. So does that answer your question? Okay, back to for sale signs. So you're going to put the appropriate signage on the property for that particular listing. You're going to obtain information regarding the present mortgages on the property. You're going to do this by asking, first of all, the seller, do you have a mortgage on the property? They're going to say yes or no. If they say yes, you're going to say, do you have one mortgage or multiple mortgages? Ask them, do you have an equity line or a secured line of credit that is attached to this property? Because that is technically a mortgage. It's going to have to be paid off at closing. A lot of sellers don't understand that those are technically mortgages, okay? Also ask, are you behind in your mortgage payments? Sometimes sometimes agents get a little nervous because they don't like to ask personal questions of their clients. We have to. We need to know if this property is about to go into foreclosure or not. Okay? When we do our CMA and we know what the property market value is, when we ask that seller right here at the listing appointment, what is your payoff if you do have a mortgage or payoffs? And do you have a current mortgage statement that I could look at? If they don't, there is a form called a third-party authorization that you can fill out that's in OutFiles. You can get this form and you can contact their mortgage company and find out what the payoff is. That is going to be more for short sales. You're not going to get a lot of those anymore. We do have a few of them that have popped back up recently, but for the most part, you can take a seller's word for it that they know pretty close to what their payoff is going to be, but we're going to get that initialed on our seller net sheet. We're going to talk about that here in just a little while. Whatever they tell you, if we take that mortgage payoff from the seller directly without seeing it in writing, we're going to get them to initial that that's where the information came was from them. Okay? Very important also, at line D, we're going to provide them with a CMA. We're not just going to wing it. Okay, we have to provide them with some information. And yes, you can get an idea of what the seller wants to sell for, but we need to verify whether or not they're even on the target, and we don't want to take overpriced listings. So you want to make sure you know what you're selling and that the seller is realistic. And if they're not, you need to counsel them. That's our job. Okay. At line E, there are several boxes here. The first is use a lockbox system to show and access the property. If we don't have a lockbox on this property, it's going to be very difficult for other agents to show your property, which is going to cut down on the number of buyers able to see the property, increasing your days on market. Okay? You can do listing agent a company if you want to, but that means you are pledging, you're promising to go out and open that house every single time there's a showing as a listing agent. You can do it. That's fine if that's what you agree to, but you have to honor that. Okay. At line 64, this one is kind of a hang up for some realtors. They really don't understand what we're doing with this line. The first option says withhold verbal offers. That sounds like a great idea, but let me give you a scenario and you tell me how you feel about this. If I check this box and you get an offer from a buyer's agent, you present it to your seller. The seller says, well, find out if they would decrease the inspection period or if they could come up to 165 instead of 160. If this first box at line 64 is checked, I have to put it in writing, everything that the seller asks, send it to the buyer's agent. The buyer's agent then has to get it in writing again from their buyer and send it back to the seller. Everything has to be in writing. Yes, we want everything agreed to and negotiated in writing when it's done. But withholding verbal offers makes you have to do a lot more paperwork in the actual negotiation phase. Does everybody understand that? We're not going to take an offer and call it executed without it being in writing, but we can negotiate by not checking this box and leaving it blank. Does everybody understand that one?
Mm-hmm.
Okay. At line 64, the second box is it says withhold all offers once a seller accepts a sales contract for the property. Let me give you another scenario. You go out and have a property offer signed by your seller. On your way back to your office to upload your contract, you get an email with another offer that's $10,000 more in cash. The offer that you have has a financing contingency on it. If this box is not checked, you have to send that to your seller. Even though the property has already gone under contract, doesn't matter. You still have to present it to your seller. How is that seller going to feel if they have a contract under, fully executed, but they get one for more with its a lot better terms? Are they going to be very happy with their current offer? No. And what are they going to try to do? They're going to try to find every way possible to cancel that first offer. They're going to grumble and make your life miserable, make their life miserable. So this is a kindness. At line 64, if you click that second box, once an offer has been accepted by all parties, we're going to just hold those offers back in reserve. We're not going to show them to the seller or even talk about it until something falls apart. You don't have to justify it. Christine just asked, how do you justify that to a seller? I tell them exactly like I just sold it to you. I don't want you to be upset, because if you were happy with an offer that we signed, it was good enough to accept it, then it's good enough to close. If it falls apart, I can keep it as a backup offer and I've already got it in place, and all we have to do is call that buyer's agent and say, hey, we're a go, are you still in? And then you can present it to your seller. But if a seller knows there's a better offer right in the wings, they're going to try everything they possibly can to get out of that first offer, which could cause you to get sued and them and cause all kinds of messes. Okay. So I would explain to them at your listing appointment, line 64 is their peace of mind clause. This is to keep you from pulling your hair out. Once we take an offer and you're satisfied, then you need to be satisfied with it till we close or it falls apart. Does that make sense? Anybody else have any questions about that? Any thoughts? You can disagree. You can talk to you can workshop about this. We can discuss it. But this is really heading off a problem before you get there. Okay. At line 65, it says at letter F, we are always transaction brokers. Right Choice Realty, you will never be a single agent. Okay, realtors that have been in the business for a while, that's what we all used to be by default with single agents. We are never single agents. Okay, so you're always going to be a transaction broker. We require at our brokerage for you to do the separate transaction brokerage disclosure as well, but it says it right in here, you are a transaction broker. At line 66, this is virtual office websites. These are VOWs. This is your third-party authorization for Zillow, Realtor.com, Facebook, Craigslist, any place that you allow it to pop up on the internet, whether it pulls automatically or you post it, this is permission from the seller that you're going to do it, and they are aware of it. Okay, at line 72 through 75, again, if the seller does not want those automated estimates of market value, that's what you see on Realist. You're also going to see them on Zillow. That's those awful Zestimates, and you know, comments to be made on their property. This is going to be on Facebook. This is going to be any place where you can blog. If they opt out by marking these two boxes, then you can't do any additional marketing other than MLS. This is different than saying they don't want their address on the property. This is saying they don't want automated value models and they don't want blogging. So again, you're increasing your days on market and you're limiting the number of buyers that you can gain exposure to if you have these boxes checked. Does that make sense? I know I say that a lot. I just want to make sure that I'm explaining these boxes appropriately. Okay. Moving on down. Now, these are the seller's obligations at line 76. This is what the seller is promising us as the brokers. The seller agrees to cooperate with the broker in carrying out the purpose of this agreement, meaning they are going to tell us if somebody approaches them while they're mowing the grass, or somebody comes to them and says, I'm interested in buying your property. They're going to tell us. They're also going to tell us if they encumber the property in any way. I'm skipping down a little bit. If they take a lease or they let somebody stay in the property even without a lease, they have to let us know immediately. Okay. They're going to provide us with keys at line 79. They're going to allow us to show the property at reasonable times. Reasonable is a matter of opinion. You talk to them at the listing appointment about what do they consider a reasonable time. At line C, this is what I just said about encumbering the property, whether they refinance it, they take out a new mortgage, they lease it, or you know, anything else that comes up that encumbers the property, they have to tell us. At line 82, they're indemnifying the broker and holding us harmless for losses and damages that happen to the property while we have it listed. This also includes expenses of any nature, including legal fees. Okay? The broker, if we incur these expenses, if we make a mistake because of the seller's negligence, representation or misrepresentation, actions or inactions, we are held harmless in that too. They're going to, you know, they're going to pay for our expenses if a seller makes a mistake. They're also going to hold us harmless if something happens while we are using a lockbox to gain access to the property. If something gets broken or stolen, we as the listing agents are not responsible for that. They're also holding us harmless for undisclosed material facts about the property. If they didn't tell us about that roof leak or that foundation settlement, or you know, they have a letter of eminent domain that is coming, we don't know about that, we can't be held responsible for what happens in that transaction. We are also held harmless for court or arbitration decisions that we didn't receive compensation for, you know, in the transaction. We are still entitled to our compensation, but we are held harmless. Okay, this clause survives the broker's performance. So if the property sells and we are in our protection period, which we're going to talk about again here in a minute, we are still entitled to that commission, even if it's expired. Okay, the seller is obligated to perform any reasonable act necessary to comply with FIRPTA. What is FIRPTA? Anybody want to talk about FIRPTA?
Foreign something.
Foreign Investment Real Estate Property Tax Act. Okay, FIRPTA is basically the sales tax on the transfer of a property to someone who is not a U.S. citizen, who does not have a social security number. This is a foreign seller, okay? It does not apply to the buyer. It doesn't affect a buyer if they're from out of our country. It doesn't matter right now, only when they sell, okay? So if a seller has to comply with FIRPTA, they're already making the pledge at line 88 that they're gonna comply with FIRPTA. At line F, they're legally required to disclose anything that they know about the property that materially affects the value of the property. Whether we can see it with the naked eye or not, they have to tell us. And they certify and represent that they know of no material facts, including government, building code violations or anything else. If you don't know of anything and you've asked this question of your seller, write in there, no known facts. So it was addressed in the listing appointment, okay? If something happens, a tree falls on the roof, or there is a leak, or something else happens during the listing period, the seller's going to immediately inform you and let you know. And I would get it in writing. Emails are great, but I would prefer that you got an actual statement. So if you get an email, turn it right around, put it on a modification of listing agreement that states that the seller's going to fix it, or it's going to have to stay like this, whatever the situation may be. Get it in writing, okay? At line 94, consult appropriate professionals for legal, tax, property condition, environmental, FIRPTA, and other specialized advice. Unless you hold a license I don't know about, you are not a professional in any one of these fields. You are a realtor, you hold a real estate license. We only give real estate advice, nothing else, nothing more, that's it. And they are automatically being referred and agreeing to at line 94 to seek out that professional advice. If you as a realtor want to recommend one of these particular specialists, you can do so, but remember the rule of 3, try to give 3 options so that you're not recommending one particular inspector, one particular accountant, whatever it may be, so they can't say that that was your, in quotation marks, your guy, okay? At line 96, this is the part that everybody loves the best. This is our compensation. Let's read through this line at line 96. Seller will compensate broker as specified below for procuring a buyer who is ready, willing, and able to purchase the property or any interest in the property on the terms of this agreement or on any terms acceptable to the seller. The seller will pay the broker as follows, plus sales tax. So at line 99, what is our brokerage fee? You can't say what is the fee because that implies the entire market, and that's not allowed. But what does Right Choice Realty charge as a standard? 6% on residential properties. On land, you can charge anywhere from 6% to 10 or 12%. It's whatever you negotiate, okay? Plus, you see right here at line 99, the Florida Compliance Commission is already built into your contract as additional commission. Okay, you don't have to worry about explaining it. You can if you want to. We'll talk later about what that fee entails and why it's there, but you don't have to do anything more. It's additional commission and it's provided for in the contract. Line 102 is usually the one that throws everybody. At line 102, we're talking about an option. What is an option? Anybody know? An option is an agreement today to purchase later. So technically what it usually is a buyer leases the property with the option to buy at the end of their lease. So in 6, 9, 12 months, they're going to close on the property, but they're going to go ahead and take possession of it now for certain terms, which are individual to every property, okay? This provision at line 102 protects you as the listing agent so that you don't have to wait 6, 9, 12 months to get paid. This says that whatever is in line 102 will be paid at the time the option is created. So if we execute it today, you get paid today. You don't have to wait until closing. You can agree to take a portion of what the normal commission would be, or you can take your full commission. It's entirely up to you. The brokerage standard is the same at the time of option as it is for a sale. So we want 6% at the time of option. Okay, does that make sense to everybody? That's the simplified, streamed down version, but that's basically what an option is. It's an agreement today to close later. Okay. At line 105 on page 3, we're talking about if the seller decides to lease the property instead of sale. Okay. Happens from time to time. You're going along great. You're marketing your property. Everything's going fine. And out of left field, the seller says, I've decided I'm going to rent it instead. That's fine. They can do so. It's their property. It's allowed. But what are you going to get as a listing agent for your time and energy and your expenses? Well, I like to call this a little bit of a punishment fee. I want that seller to reconsider taking that rental, if at all possible, if I've got a good chance of selling it. I don't want to persuade them not to rent if that's their best option. But if I think that I can sell it, and in my professional opinion, I've listed it well, then I don't want the seller to take a rental. So what I'm asking for on line 105 is 25% of the gross lease they will receive. So if they get $1,000 a month, that's $24,000 for the year. I want a quarter of it. Do you think that's going to make the seller think twice about taking a rental versus keeping it on the market to sell? Yeah, I think it probably will. Like I said, I don't want you to punish the seller with this fee, but this protects you from losing a possible sale to a rental. Okay, the broker's fee at line 108 is due in the following circumstances. If any interest in the property is transferred, whether by sale, lease, exchange, government action, bankruptcy, interesting, or other means of transfer, regardless of whether a buyer is secured by seller, broker, or anyone else. Fee is due. You've earned your 6%. If you get this property conveyed or the seller conveys it during this time period, you are owed your full commission. Now, sometimes it's a little iffy about how you're going to get your money at bankruptcy. You'd have to file a lien against the seller on this property, again, make it a recordable situation so that the bankruptcy court would know that you actually have a claim against them. But this counts. If they transfer it or they trade it for something else, you are still owed your commission fee. Okay. Number 2, at line 110, if seller refuses or fails to sign an offer at the price and terms stated in the agreement, defaults on an executed sales contract, or agrees with a buyer to cancel an executed sales contract, you're still owed your commission. So if they don't close and you brought them the terms of this contract, you are entitled to a commission. If they default, they refuse to close after you get it under contract, you're owed your commission. Or if they try to cancel this agreement and then go back to a buyer that has seen the property or made an offer on the property while you have it listed, you are owed your commission. At line 112, if within 180 days after the termination date, whether it expires or it's canceled, that a prospect that saw this property comes back and buys the property and it's not been listed with another realtor, you are owed your commission. If they list it with someone else, though, you have nothing. You can't go back and try to get them after it's listed with someone else. Does that make sense? Anybody?
Well, just a scenario here. So let's say your contract is terminated and, you had an interested buyer perhaps a week before the contract ends. Mm-hmm. In 2 weeks, that same buyer comes back through another realtor, you're out of luck.
No. If they come through another realtor representing the buyer, you are still entitled. If the seller lists with another realtor, if they put it back on the MLS, they put it back under listing contract, then you're out of luck. But if it is not relisted, it's still your buyer.
But if it's relisted and that buyer that that came through while you were the listing agent, you're out of luck as long as it's relisted with another agent.
Yep, look at line 115. No fee will be due, broker, if the property is relisted after the termination date and sold through another broker. So if they relist it, and that's the key word there is if. If it's not relisted, you're still owed if it's someone that looked at the property while you had it listed. Okay. If it's somebody new that never came and looked at the property before or had no communication with you about this property, then no, you're not owed anything. The seller can sell it themselves if it's somebody new. But if it's anyone that looked at the property while you had it listed, then you're owed the commission if the seller sells it to them. Okay. At line 117, this is retained deposits. If a contract is canceled, if it dies a terrible death, whatever the retained deposit is, so let's say it's $1,000 in escrow. If the seller is entitled to the escrow deposit, you are entitled to 50% of it. Okay? You don't have to take it. If you're going to put the property right back on the market and you're going to move forward, then maybe you're going to decide to not take half that money that the seller is entitled to. But if the seller says, that's it, I'm done, I'm taking it off the market, I just can't do this anymore, the stress is too much, then you are entitled to 50% of whatever they retain. Okay? Does everybody understand that? Okay.
Yes.
Outline. Go ahead, I'm sorry.
I was just saying yes, yeah.
Okay. At line 120, this is the cooperation and compensation to other brokers, okay? You have to disclose what you're going to offer another realtor that brings you a buyer, okay? We said back here at line 99 what the total commission is 6%. So how are you going to split that with another agent? Do I have to split it evenly? Am I required to split it evenly? No, I'm not. I can split it however I want to. If I want to keep 5% and only offer 1, you can, as long as you disclose it right here in this number 9, lines 120 through 126. That's probably not going to make you a lot of friends and get other realtors to want to share your property. But if you have a particular property that's going to require a lot of marketing and I want to keep 3.5% instead of keeping only 3, I can do that. I can offer 2.5% out to a co-broke. Okay, does that make sense?
Yes. What are you putting though in that first blank line at 123? You have a number symbol.
That should have been a 3.
Mean?
That should have been a 3.
Oh, okay.
Just a boo-boo.
Okay.
I'll fix that in
Okay.
the actual one that's in app files. Yeah, apparently I hit shift and so now we have a capital 3. So yeah, you can also do a flat fee. So let's say this is a unique fixer-upper opportunity and the house is only worth $25,000. That would be a real interesting property, most likely in our market, but it happens. Maybe you get one that you just need to, help the seller move on so they can get on with their life. You do not have to take a percentage. You can do it for a flat fee, a dollar amount, instead of doing a percentage. So let's say, if it's a $25,000 property, what's 25,000, 3%? That's only $750 that you're offering in a co-broke. So that's not a lot of money. You could say, I'm going to offer to list the property for $5,000 and I'm going to offer $1,500 out to another realtor. However you split it, it doesn't matter as long as it's disclosed. That's the major key here, is that you have to disclose, and whatever this says at line 120 to 126, that's what has to go in the MLS. At line 126, it says none of the above. I'm not offering anything. If this box is checked, you cannot put it in the MLS. You cannot put a 0 in the MLS. Okay? You have to offer to pay another realtor if you put it in the MLS. A lot of realtors out there think that if you take a listing, you automatically have to offer it as a co-broke. Is that true? True or false? It's false. You can check this line 126, not put it in the MLS, but put a sign in the front yard and you can sell it yourself. You do not have to put it in the MLS. If you're not going to pay a co-broke, you can't put it in the MLS. Okay? They used to call those pocket listings. At line 127, we are disclosing one more time that we are transaction brokers. There's only 4 duties of a transaction broker that are required: dealing honest and fairly, accounting for all funds, using skill, care, and diligence, and disclosing all known facts. The 5th thing is anything that the seller asks you to do in writing that you agree to. Okay, so those are the things you're going to see on your transaction brokerage disclosure. There are 4 main ones, and then the 5th one is anything else they ask you to do in writing. Okay, we disclose again, and disclose one more time just to make sure. Why do you think that's important? What does a transaction broker really mean? Who am I representing? Or what am I representing is a better question. It's right in the name. I'm representing the transaction. I'm not representing anyone in particular, I'm here to get the deal done. I am a facilitator only. If you're representing someone, you're acting as a single agent. And we said at the beginning of this workshop, we are never, ever single agents in this brokerage, okay? You can behave as a single agent, I'm sorry. You can give those additional duties, but officially we are transaction brokers, okay? Any questions about that? Okay, at line 132, this is important, okay? This is so important for agents to understand. Every broker has their own way of doing things, and this is how Right Choice Realty handles terminations. At seller's request, the broker may agree to conditionally terminate this agreement. If the broker agrees to a conditional termination, the seller has to pay the cancellation fee of X at line 134, and they have to sign the withdrawal agreement. So they have to sign it first, they have to pay the fee. If you put a 0 in this box, we have no way of enforcing your listing agreement. You might as well just go ahead and tell them, sure, I'll cancel it, okay? Our broker Beth prefers that we put $1,000 in this blank. I think you can adjust it for the amount of the sale price. If it's a $3 million property, then sure, $1,000 is probably appropriate. If it's our $25,000 unique fixer-upper we talked about a few minutes ago, $250 is probably more appropriate. You can decide as the individual agent, it's your business, what you want to put in here, okay? You can always waive this fee. You can say, no, I'm not going to enforce that. It's, your decision. But if you don't have anything in there, we don't have any teeth to be able to enforce it for you. We don't have anything to back it up. So please put something in this box. Again, you can waive it, but you have to have something to make it a little discouraging for a seller to just back out. I want to go back over that first sentence one more time. The broker may, and if they agree. That doesn't say she will. That doesn't mean we're going to just terminate at a seller's whim. We might. We need to know why they're terminating and what you've done as a listing agent to remedy this, to try to hold on to that listing. We don't list for fun. We don't list with exit clauses. We list to sell. That's why we're here. They're hiring you to sell their property. I don't want you to give yourself an escape hatch that makes you come from a position of weakness. Does that make sense?
Yeah.
Okay. All right. At line 139, we're talking about dispute resolution. In Florida, we have to go to mediation first. The seller is automatically agreeing in this paragraph to go to mediation and to try to work it out between a buyer and seller. Who is the first mediator if a transaction gets complicated? Who is the first line of defense in trying to work something out? You are. The buyer's agent and the listing agent need to work together to try to resolve whatever the problem is before it goes any further, okay? You have 10 days. If you can't get it resolved in 10 days, you have to inform your broker that, hey, I got a problem. I got a problem here, Houston. If the escrow is being held by a real estate company, which we don't hold escrow, we use a title company to hold all of our escrow. Some brokerages have their own escrow accounts. If it's being held by the brokerage, we have to send it to FRAC if there's a dispute, an escrow dispute. If it's held by a title company, the parties to the dispute have to file a small claims, well, sometimes not small claims, depending on how much the escrow is. They have to file a suit against each other in the municipal court. So it depends on our negotiation skills on how we can mediate this. We are going to talk about this in a follow-up session about how you can be that mediator and how you can problem solve and get, situations diffused. But just know it is your responsibility to try to diffuse and bring that back to zero. Try to get that situation fixed before it goes to the next step. If it cannot be resolved by mediation, at line 144, seller is agreeing, you initial it as well, and then you send it over to the broker to get initials that says, we will go to arbitration. We will take it the next step to get this resolved. okay? The important thing here is to understand if you go to arbitration, it can get expensive. He who loses pays for everyone. All right. So if you aren't 100% sure that you have a solid stance in this, you need to continue to try to mediate. If you know legally you've talked to an attorney or you have everything behind you documentation wise saying no, they're wrong and I'm right, not maybe, but 100% right, then go to arbitration. Great. Let a judge decide. But if you're not, mediation is the way to go. If not, somebody's going to end up paying and you're not going to be real popular if it's your seller on this side, okay?
So as a standard, we leave that blank in because it's our recommendation that mediation is the way to go.
Well, mediation is already agreed to. By signing this listing agreement, they don't have a choice. They have to agree to mediation first. And it'll be informal mediation, meaning broker to broker first. If they cannot get it worked out, then we're going to refer it to a mediator. Usually it's the Board of Realtors. We refer it over to a mediator, and the parties to the mediation have to split the cost of the mediation. It's usually $500. So they're going to split those costs. And then if that fails, if they still don't agree to what the mediator comes up with, then we go to arbitration. It is, again, your business. You can decide whether or not you have them initial this box or not. I always personally have them sign it because I want my seller to know that I'm coming from a place of strength, that if something fails, I'm going to go to bat for them all the way to court if we have to. Okay? It's up to you. It's your personal business whether or not you get them to agree to arbitration or not. If you don't, it doesn't prevent you from being sued. It's just not disclosing it. Does that make sense? Okay. Last paragraph before we get to additional terms is miscellaneous. This agreement is binding on on sellers and the brokers and their heirs. So if someone passes away while you have their property listed, they're still listed. Whoever inherits that property, their spouse, their children, a trust, whoever it is, they're still listed with Right Choice Realty and you, okay? That could be a personal representative, administrator, successors, or assigns. The broker may assign this agreement to another listing office. So if you need to share it with another realtor, or if you leave our company, you can assign this listing agreement. It doesn't have to be canceled and start over. It can be assigned. This listing agreement is binding on the seller or broker unless included in this agreement. Or no, I'm sorry, I read that wrong. No prior or present agreement representations will be binding. So in other words, this is the only deal you have. You don't have something before, you don't have something after. This is it, okay? Electronic signatures are acceptable and are binding. Signatures, initials, and modifications communicated by fax are also considered as originals. So that's kind of outdated. But when they sign this, however mode they sign it, it's binding. Okay? And the term buyer used in this agreement includes buyers, tenants, exchangers, optionees, or any other category of potential or actual transferees. Okay? So again, this goes back to what is your compensation due? Anytime the property is conveyed in any way, that's considered a quote-unquote buyer. Okay. Anybody have any questions about what happens if somebody passes away while they're under contract, or if they put it into the name of a trust while you have it listed, or in an LLC? It's still binding. And it's also binding on you. So if something happens, if you pass away, God forbid, but if something were to happen to you, the broker is still responsible to that seller as well. Okay? Any questions about that? All right, moving on to my favorite section of this contract at line 157. This is the additional terms section. This is your magic carpet. Realtors are not allowed to write law, so we have to be very careful in our wording. We cannot say shall or will. We can say requests or seller wishes to convey, or things do not if they are the seller's terms, such as light fixture in the foyer does not convey. That's a statement from the seller. That's not us writing law, okay? You can say no showing appointments between 7 p.m. and 9 a.m. or no showings on Sundays. You can put that right in your contract. You could also put something in your additional terms to say price to be monitored. If no acceptable offer is received within 14 days of listing, seller authorizes agent to reduce price by $1,000 every 2 weeks until an offer is accepted. Whatever you and the seller agree to, you put in this contract. And it has to be in writing. If it's not here, it needs to be on a modification of listing agreement. If you change the price and you don't have a provision in your additional terms, you have to do a modification every single time. Okay? So if you have a short sale, for example, you can put right in here, property price will be reduced every 2 weeks until an offer is accepted. Then you don't have to chase paperwork, especially with a short sale, because sellers aren't going to make any money anyway, and they get very squirrely about doing paperwork. They don't want to be bothered. They just want to be done. So if you put those provisions right here in your additional terms, you have protection to be able to make those adjustments without getting in trouble. Any questions about that?
Dawn?
Yes, ma'am.
Yeah, this is Christine. So also you would put here, if you as the agent are agreeing to contribute any dollars towards closing. So for example, sometimes I like to offer a $1,000 incentive for people to go with me. That would go here as well, right?
Yes, ma'am, you sure can. You can also put right in this section, if you represent both sides of the transaction, you can reduce the commission. So if you're listing for 6% back at line 99, but you also represent a buyer, you can offer an incentive to a seller and say, I'll do it for 5% if I represent both sides, or 4%, or whatever you want to do it for. You can put that right in here, and that way you don't have to do additional paperwork at closing. Okay? Any additional comments on that? Very good. Okay. On this contract at line 178, you are the authorized sales associate. Okay. So it says authorized sales associate or broker. That means sales associate or associate broker. That doesn't mean the broker of the firm. You sign this as the authorized agent. Okay. You're accepting this on behalf of the brokerage. If there's something strange or there's term that you're not 100% sure goes along with the brokerage requirements, you can always ask us to review it. You can send it to me and I can look it over before you agree to it. But you go ahead and sign this and get it going. You don't need to wait on anyone from the brokerage to look at it before you list it and put it on the MLS. Okay? You do want to list the brokerage firm that have the address, the telephone number, all that information, and you do need the seller's contact information. If you don't want to put it on here, that's okay, but you do have to have it required in your app file. Okay? And the last but not least is line 181. This is when everything is finished and it's returned to the seller. That's when it's fully executed. Now I have a real listing. Okay, if you use electronic signature, you don't need to do anything else except check this email box right here because they're going to automatically get a copy of it back. If you fax it, mail it, or drop it off in person, you need to mark that box about how you gave it back to the seller because now they have a listing agreement. They have been given their notice that we are active. Okay, anybody have any questions at all about the exclusive right of sale listing agreement that we just covered? Okay, great. The next thing that we're going to talk about is this seller net proceeds sheet. Can everybody see that?
Yep.
Okay. This is probably the most important document, at least from the seller's perspective, of the listing package. All right. We need to have done our homework ahead of time to get a lot of this information to be able to do this seller net proceeds sheet. We need to know what their mortgage payoff is approximately. We need to know what the prorated taxes are. We need to know if there's any assessments due on the property. These are homework factors that you're going to do ahead of time before the listing appointment. Okay? I know sometimes you get that phone call that says, hey, can you stop by in an hour? Yeah, that's great. You can. But you want to at least have done a cursory CMA and done these couple of stops, the property appraiser's website for taxes, and if it's in the city of Cape Coral, you want to look and see if there's any assessments. Now, who imposes the assessments that we're talking about on this net proceeds sheet? What kind of assessments are we talking about here? Anybody?
The city for water and sewer and things like that.
Correct. This assessment that we're talking about is a government-imposed assessment that would be city, state, local, or federal for community projects such as sidewalks, city water sewer, irrigation, street lighting, road paving, okay? These are things that benefit everyone, and you're going to be assessed by the government, whatever level it is, your portion of that community project, okay? So we need to know, what are we being assessed and what is the balance of that lien that's due, okay? So if you're in the city of Cape Coral, you need to get real good about going to the City of Cape Coral website and knowing how to find those assessments. I am going to do a training on that. I'm going to just record it. I'm not going to have it open as a to meeting. It's too much information, but I will record it and go through the steps and show you how to find the assessment payoff and how to do it. And I'll post it so that you can go back at any time and follow it along. Okay. Same with prorated taxes. I'll pull up a prorated tax bill and show you how to do those as well. Rule of thumb for taxes is very easy. And I'm going to go through that here in just a second. Okay, we're going to quickly go through a sale price of $130,000. So if you have a scrap paper in front of you and a pencil and a calculator, we're going to do this. I can do this and do it on the form live, but it's going to be in the smaller version. It won't let me keep it on this big version. So let me see if I can do it and you guys can still see it. Can you still see this well enough for me to be able to fill it in as we go?
Yeah.
Okay, so we're going to start with $130,000 sale price. Our dock stamps, these are the sales taxes that are owed to the state when a property sells. Regardless of how it's financed, whether it's cash or mortgage, this dock stamp applies, okay? So we want to do the sale price divided by 100, all right? That's going to give us 130. And then we're going to, I'm sorry, 1,300, and then we're going to multiply that times 70 cents. And that gives us a price of $910. Did everybody follow me on that one? So sale price divided by 100 times 70 cents gives us 910. Are you with me? That one's usually pretty straightforward. This is the one that messes everybody up. Our sale price is $130,000. For title insurance, the first $100,000 is always $575. That's divided by 1,000 times $5.75. Did I lose anybody on that one? Okay, so if we take 130 and subtract our first $100,000, what does that leave us as a remainder? 30,000, right? So we take 30,000, divide it by 1,000, that gives us 30, and we multiply it by $5. That's an additional $150. We add that to our original $575, and what is that total? $725. Everybody with me? Did I lose anybody on that one? Okay, I'm going to trust you. Okay. The title search and exam fee is going to vary from title company to title company. You will see them be right around the cost that Security Title and Abstract charges. You're going to see them, if an attorney closes this, be upward of $2,500. You need to find out if the seller has a preference on who closes, and if so, you need to find out what the title fee is. If we use Security Title and Abstract, which is our in-house title company, it's going to be right around $450. Okay, so that's why it's pre-printed in there. That does not mean that's what it will be if you go somewhere outside of Security Title and Abstract. Okay, we're going to use $450 for this example. Our commission we set on our listing agreement was 6%. So 130,000 times 6% is $7,800. Okay. Our brokerage fee, this is the Florida Compliance Commission. If you are over $75,000, it's always $295. Okay, so it's pre-printed. If you're under $75,000, we can change this. And I'm going to show you another form that is called a 3-up comparison Seller Net Pro sheet that you can use, that you can actually edit this. Okay, miscellaneous closing fees, this is a junk fee. You're going to see that this fee will change. You may not use all of this fee. This is recording fees. This is a mobile courier, a notary, wiring fees, anything like that that is extra that's outside of these other expenses we've already talked about. If we don't spend it, we give it back to the seller. Okay, but you want to pad your number just a little bit so that we're on the better side of the seller rather than the worst when we get to closing. For this example, we are not going to include a home warranty fee, but why is a home warranty a great service to offer if you're a listing agent or if you can convince a seller to use it? Why is a home warranty a benefit in a listing? Anybody know?
Takes away the concern of things breaking down for the first ownership period.
Right, exactly. It's an insurance policy. So if they move in and in 2 weeks the water heater dies or the air conditioner dies or the stove dies, they're covered. And there's different levels of policies in your actual purchase agreement. You can set a limit on how much a seller or a buyer will provide for a home warranty, or you as the agent or the buyer's agent's going to provide. You can cap it. And it will vary on depending on what type of services you want covered. If you want the entire structure covered, it's going to be more expensive than if you just do the appliances and the hot water heater. Okay, so there are some examples here in the office in the workroom. You can get some of those brochures. You can go online and check out different vendors. You know, there's lots of good options out there. And this is a great way, especially with older homes, to help make a buyer feel comfortable enough to choose your listing. Okay. Seller concession, the next line, this is what we were talking about on the first page of our listing agreement about preparing a seller to contribute towards a buyer's closing costs. The maximum generally is 6%, so it's going to be equal to our commission. That's a lot of money for a seller to donate back to a buyer. It can be anywhere in there. Maybe they only need $1,000 or maybe they only need half that. But we want to prepare our seller for the worst case scenario. So if they get more back at closing, they're happy. If they end up getting $7,800 less than you anticipated, are they going to be real happy with us? Probably not. And you know, they don't have to do seller concession, but again, that limits our buyer pool by refusing to pay seller concessions. So we want to just prepare them ahead of time. At lines, the next two lines, the mortgage payoffs, first and second mortgage, we are going to get this information either off of a mortgage statement that the seller provides us, which is probably a lot more accurate, or a seller can tell you, I believe I owe about $112,000. That information, if you put that in here, I'm going to put it in and then take it back out of our math, but I just want to show you. If you, oops, wrong line. If you put that in here as your mortgage payoff, I want you to have the seller initial it right out here to the right of that block. That makes it known that you got that information from the seller. Okay, I didn't go gather that. That's not an official payoff. That's what the seller told me my payoff is. And the same for the second mortgage. Okay, for our math right now, I'm going to make it a 0. But I just want you to be aware, if you take the information from the seller, please have them initial it. Okay, prorated taxes, you're going to get from your property appraiser's website. You're going to go to the last paid tax bill, and you're going to get the total taxes for the previous tax year. For this example, we're going to use $1,200 as a total tax bill. I'm going to divide that by 12 months, and that gives me my monthly tax assessment. So for this property, that would mean that my taxes are $100 a month. Does everybody follow me on that? So if I were today at February 26th taking this listing, what is my average days on market in your area right now? What is the average days on market for our county? Does anybody know?
I think it's 4.5 months, actually.
Okay, so how many days is that? How many months is that? So 4.5 months, right? So that's going to be, this is already February, so that's 1, 2, right? March, April, May, June. Let's go ahead and go through July because we don't want to count half months. We're going to go ahead and say that by the time this property goes under contract and closes, my seller will have owned the property for 7 months. Does that make sense?
Yep.
Okay, so how much am I going to anticipate my seller having to pay at closing in prorated taxes? 7 months.
$700.
So $700. Very good. So we're going to put $700 in there. I always asterisk it and tell the seller that is for 7 months. Okay, I give them the information as to how I'm coming up with that number. Okay? Does that make sense? If it's 4 months, it would be $400. If it's 12 months, it's the whole tax bill. Okay? It's for how many months we anticipate it's going to take us to sell the property plus the amount of time that's already elapsed in the year. Okay. The next line is assessments. We've already discussed that these are special assessments that are imposed by a government body. Most frequently in our area, it's going to be City of Cape Coral. It's going to be water, sewer, and irrigation. We are going to find this information out and verify it and put it in our assessments. If we don't know, don't guess. Put in here to be determined, and a new net sheet will be issued. Okay? Don't guess, because it depends on how much road frontage a property has. If it's on a corner, it's twice the amount or almost twice the amount of the assessments as somebody that only has single frontage. So don't guess. You don't want to anticipate it being $16,000 when it's really 25. Okay? You want to verify it. If the seller has the assessment bill and they want to give it to you, again, put that in there and then have them initial it. Everybody good with that? For this example, I'm going to make it 0 again because we don't have that information. We're going to do that in another workshop. I'm going to do it later today and post it for you, but I want to just use this example as a 0. Okay, so the last but not least example or expense on our list says other. What kind of other expenses might a seller have that we haven't already covered? Anybody have any ideas? How about
would there be home improvements, maybe?
Maybe liens, home improvements, good, okay. An outstanding electric bill, if this is an investment property or maybe even a foreclosure, might be an outstanding bill. Donna just said outstanding HOA fees. Yes, it could definitely be an HOA fee. Liens, yes, Aaron just said maybe a lien. Anything that is outstanding that we know about when we list. Now, we don't always know, and sellers don't always disclose because they don't really think about it. I'll give you a personal example. I had a seller one time that had a felony against him. It wasn't murder or drug charges or anything like that. It was actually imposed by the Florida Wildlife Commission, and it was just something, he didn't go to jail or anything like that, but it showed up on his record as a felony, and he had a lien imposed against his property for his court costs by the Federal Wildlife Commission. So when we went to close his property, this popped up as a lien. He had no idea it was even there, and it was a couple $1,000s, and we had to satisfy that when we closed. And we had a really good laugh about it because it was, you know, something that actually the federal government repealed this as a felony later, and it came off of his record. But at that time, that came up as a lien that we had to satisfy. So that could have been something that comes up and goes under this other category. So anything that you know about, and you need to ask these questions of your seller. You need to ask leading questions. Is there any other lien or other expense that is outstanding against the property that we need to include that's going to have to be paid off at closing? Okay. This could also include outstanding IRS taxes. This could include back child support sometimes, depending on how that lien is filed. So just be prepared that things are going to pop up, maybe, hopefully not, but could pop up in title that you did not know about or the seller was not aware of, okay? For this example, we're going to use a 0. Okay, so if we go through and we add up all of this column together, we get our total expenses, which I cheated and did them earlier, and have our total expenses. This is what it's going to cost the seller to sell. Hang on one second. Oops, typo. So it's going to cost my seller in all of their fees, including commission, seller concession. Now that's a worst case scenario. It's going to cost him approximately $18,000, almost $19,000 to sell this property, which is going to leave him with a net of $111,000. Does everybody understand how we came up with that number?
Yep.
I'm double checking my math just to make sure I'm right. Pretty close. Close enough. So your number, you need, oh, I forgot my additional taxes in there. Okay, so your number needs to add, you need to add backwards and come up with your sale price. Everybody got it?
Yep.
Okay. This seller net sheet, you can also use this 3-column net sheet, which allows you to compare some price. If I listed for 130, if I listed for 135, or I listed for 140, I can take this with me to my listing appointment, and I can show the seller what the difference is going to be if we list at 135 but we actually get 130. Okay, so you can show them a side-by-side comparison of what 3 offers would look like. Let's say you get lucky enough to get multiple offers. You could use this form also to write down the 3 offers and show them what it's going to look like for them and what it means to them in expenses and different prices. Okay, mentors are required to use a seller net sheet. Independent contractors should require themselves to use a seller net proceed sheet. Mentor agents are not allowed to go to the title company for a prelim HUD. I want you to be able to work this net sheet, at least this top section, on a cocktail napkin, at a barbecue, at the bowling alley. I want you to be able to, wherever you are, be able to know this math and be able to come up with, if I listed for X, what would be my approximate net without my mortgage payoff and taxes, etc. Well, what's my ballpark? So you need to be able to do this math and also do it again if a seller says, well, what if we listed instead of 130, what if we listed for 150? What's the likelihood of my property selling for that? And if so, what would my net look like? Okay. It's really important that you be able to do this math in your head quickly and know what this formula means and what it's for, so that you are the consummate professional when you take your listing appointment. Step number 1 of a listing appointment is actually getting the appointment. Number 2 is closing it. Okay? If you get it, but you don't know what you're doing with your paperwork, or you don't know how to answer these questions, you're probably going to have a lower success rate in closing your listings. You got to have these tools. Does everybody understand the fundamentals of the net sheet?
Yes.
Anybody have any questions about this one? Okay. Well, without further ado, that is going to wrap up our listing section. Look for a little later today, I will post this workshop as well as the City of Cape Coral assessment walkthrough, and the I'm going to use LIPA because that's the majority of our closings are going to be Lee County. The prorated tax assessment walkthrough. Okay, thank you guys so much for participating, and we will see you next week.
Thank you.
Bye.